This is episode number 1 of the Financial Poise series on post-grant review trials. You can read more about financial poise on slides 2 through 4. I'd like to introduce our panelists. We have Jeremy Albright of Norton, Rose, and Fulbright. We have Brooke Parker of Haynes and Boone. We have Andrea Schaafsal of Unified Patents. And I'm David Tobin of law firm McDermott, Will & Schulte. Our bios are at the end of the presentation. Please review them, visit our websites. Neither we or Financial Poise want this to be an infomercial, so we're not going to spend too much time on our own bios, and we'll launch into the topic. About the slides, we do have a slide deck here. We'll try to call your attention to the slides when we're talking about them, so you can take notes if you like. But if you're just listening to this over audio and not watching this webinar, that's fine too. You'll be fine and don't need to review the slides while you listen. Last, before we begin, slide 5 contains a disclaimer. You are not our clients. We are not your lawyers. What we do here today is for general education and not for anyone to act on it without appropriate legal advice. So let's get into it. We'll go to slide 12 of our deck here, and we'll start with you, Brooke. And you're on mute. What are the 3 types of post-grant proceedings to challenge the validity of a patent, and can you give an overview of the differences between them?
Sure. So there are 3 different post-grant proceedings, and there's actually one that's listed a derivation proceeding that doesn't really happen after the patent grants necessarily. And there's one that we don't have listed here because it's not reviewed by the PTAB. Just a quick note. But the kind of main and most common procedure is an inter parte review, also called an IPR. This is when after the patent grants, 9 months after it grants, you can challenge the validity of the patent on limited grounds. So you can only challenge it based on novelty and obviousness, and you have to challenge the patent with patents and printed publications. So this gives anybody an opportunity to challenge any patent. Oftentimes it's used when a party is sued in district court for infringement. So they'll file a petition for an IPR with the patent office to review these limited issues of validity, to try and decrease the number of issues that are before the district court. Another post-grant grant proceeding that's very similar to an IPR is a post-grant review, also called a PGR. In this proceeding, you can challenge the validity of a patent less than 9 months after it issues. So if it's less than 9 months, you would go with a PGR. If it's more than 9 months, you go with an IPR. A PGR allows you to challenge more grounds of validity of the patent. So you can challenge the same things that you challenge with an IPR, so novelty and obviousness, but you can also challenge things like whether or not the specification supports the written description or enablement of the claims. You can also challenge based on 101 grounds. So it gives you more of an opportunity to challenge different weaknesses of the patent. Derivation proceeding is the 3rd one listed. This is a very rare proceeding. It is essentially, it focuses on one very particular type of controversy. So in 2013, when the American Invents Act went into force, it established what we call the first to file system. So before that, it was the inventor who invented the patent first could file a patent on it, even though if there were multiple people who invented it, the first one was the first person to actually invent it was the one who got the patent on it. After 2013, what we had is, or starting in 2013, what we had is this first to file system. So if multiple people invented a particular invention, the first person who files an application with the patent office is the one who gets the patent. So even though if somebody invented it first, they still wouldn't get a patent if they didn't file before the other person.
So Brooke, in terms of in terms of commonality, how would you rank the three different types of proceedings before the PTAB, just in terms of the frequency in which they're filed?
IPRs are filed by far more than any of these other ones. An IPR is they're about give or take like 12,000 or so petitions that I think are filed per year. A post-grant review, there are maybe several dozen, couple hundred that are filed every year, just because of the limited time frame that you have, because you can only do it within 9 months of when the patent issues. And a derivation proceeding, those are extremely rare. They really only come about in like particular cases when you're trying to decide if a person who filed an application stole that invention essentially from the person who actually invented it. And so that happens very rarely. I think I saw a statistic that only 6 of them were filed in the year 2023. So they're really uncommon.
Great. So Andrea, turning to you, at a high level, I want you to compare what we call trial before the Patent Trial and Appeal Board, or PTAB, and how that compares to trial that's more common, like before a jury or a judge in district court.
Sure. So there are quite a few differences, but I'll try to highlight, 3 of the biggest differences between these PTAB trials and the common, as what everyone knows, district court trials. The first one being the adjudicators, right? Who's making the decision, who's deciding your case. Before the PTAB in an IPR, for example, there's a panel of 3 judges that get assigned to your case. We call them APJs, or administrative panel judges. They usually have, for the most part, some sort of technical background, the APJs at the PTAB. Maybe they were examiners in the past for the PTO. Maybe they were patent practitioners like us that are now APJs for the PTAB. So they have a very solid understanding of patent issues. Comparing that, right, to a district court case where you're assigned one federal judge, maybe a magistrate as well. They may or may not have experience with patent law and patent specific issues. Of course, we know anyone that's a practitioner out there, the notorious courts for patent issues, right? And judges that seem to handle a lot of patent cases, but that's not always the case, right? So you don't have the technical background guarantee for these sometimes very difficult patent issues. The other thing is, of course, if you take a district court case all the way to trial and have a jury trial, you have the jury deciding a lot of the infringement and specifically invalidity issues. So different than just the panel of 3 judges in the PTAB, specifically in an IPR. Another one is the scope of the proceeding, right? Which I think Brooke mentioned. We're only dealing with validity issues in an IPR, PGR. You are not dealing with infringement. You're not dealing with damages. You're not dealing with potentially any corollary contract issues that might come into play in a patent infringement lawsuit, right? You're only dealing with validity issues before the PTAB. PGR has a little bit broader as of validity issues, as I think Brooke mentioned as well. You can challenge the patent on different grounds, many more grounds of validity than you can in an IPR. So just to note that. Also, because you're focusing on just validity issues, the timeline is a lot faster, and it's a statutory timeline. So the PTAB does have to follow the timeline that's set forth in the statutes, whereas we know sometimes district court cases and trials can go on for years and years. And the kind of the last big difference I wanted to note is the burden of proof. And I think we'll talk about this a little bit later in more detail, but you have a preponderance of the evidence burden of proof in the PTAB proceedings versus clear and convincing evidence in the district court. So theoretically, the standard and the burden of proof in a PTAB proceeding is lower than that in a district court. So it's theoretically easier, and I say that with quotes because none of this is easy, right? But technically easier to invalidate a patent at the PTAB.
So Jeremy, turning to you, in terms of, let's say, writing style or how you would present the issues to these technical judges at the PTAB, how does that compare or contrast to the writing style that you would use for, let's say, a district court judge, either in a more common patent district or a less common one?
So at the PTAB, I would definitely focus on the validity issues. So it'd be the prior art, how it meets each of the claims, a detailed description or explanation of any motivations to combine. So really focused on the prior art and how it meets the claims, the novelty and non-obviousness positions, Whereas in the district court, I feel like the writing can be sometimes a little more bombastic and focused on the conduct of the other party as opposed to the actual legal and factual issues. And in my experience, that's what the PTAB is interested in. They just want to know about the validity of the patent that's being challenged. And otherwise, I'll throw that out to the panel. I'd be interested to hear what other folks had to say.
Yeah, I tend to agree. What's most important is it's critical to connect the dots, show how, like you said, and get into the weeds and be able to explain it. So I fully agree with that. Has in terms of the makeup of the panels, and you know, some of the PTAB judges are on LinkedIn and have their technical backgrounds, some are not. But in terms of the mix of panels of APJ panels that you get, what's been our panel's experience in terms of, like, are they all specifically on the technology of the patent issue? Or some have those technical backgrounds? What's been the panel's experience on that? Our panel's experience on that?
I'll say that my experience has mainly been that it's been a mixture, not necessarily all of the panelists have backgrounds in the particular type of engineering that underlies the technical issues that we're dealing with. But I will say it seems like they do, for the most part, line up with the technical expertise. And I know that a lot of stuff goes into that, right, in terms of staffing and workload and management and things like that. But I have found that it's been a nice mixture. I have always felt that they are extremely well suited and, you know, very, very good at their jobs, whoever the APJs are that have been assigned to my cases. So regardless of whether or not their expertise lines exactly with the technology at issue, they've always been really, really good at assessing the technical and the really tough issues.
Yeah, great. Let's move on to the next slide, and we're on slide 14 now. And I guess, Andrew, while we're on you, at a high level, can you summarize just some of the back and forth nature of a case? And I'm sure we'll discuss the timeline in much more detail. But just at a high level, describe the back and forth nature of how the flow of a PTAB case.
Yeah, so there is a decent amount of back and forth, right? Because this is an adversarial proceeding, although it's different than a typical district court case and trial. There is a lot of back and forth and a lot of briefing. But the first starts with, of course, the filing of the petition. And that's going to be the petitioner, the person or the party who is challenging the patent. They will file the petition. Assuming it's accepted by the PTAB and there were no issues, the patent owner then gets an opportunity to respond. Some choose to respond, some do not, within 3 months of the filing of that petition. And then 3 months later, and again, we'll get into more detail in the timelines, but within 6 months of filing the petition, the board makes a decision as to whether or not to institute. From there, if they do institute, there's a briefing schedule that's set. It follows through, you know, throughout the next year, next calendar year, ending with, in most cases, an oral argument or an oral hearing. And from that oral argument, it's usually about a couple months after that. And of course, the timelines are different depending on the case. There will be a final written decision that's issued by the board after all of the briefing between the parties. But again, this whole timeline is no longer than about 18 months. I think in some cases 12 months, but it all happens pretty quickly. And there's a lot of briefing. I don't think it's any more than 3 months in between when you usually have to respond to either the patent owner's reply, and then you can file potentially a SIR reply and things like that. So it's a couple months in between each of the filings for the most part. So it moves pretty quickly.
Great. So let's take a step back and talk about more strategically, and we'll go to slide. So we're at slide 15 now. But Brooke, can you give us what are some of the reasons why someone would file a petition for a post-grant review trial rather than just, for example, let things ride in district court and deal with it there?
Well, I think one of the main reasons that Andrea just pointed out is our timing issues. By statute, the board has to issue a final written decision within 18 months. So the proceeding is very fast paced, and you get an answer very quickly. And so the board cannot, delay hearing, delay a decision on that. So if you're in a district court that moves very slowly, you might want to get these issues handled as quickly as possible, because that may decrease the number of issues that you have to present to the judge or jury down the line in district court. Some other things you would also consider are the scope of the argument. So if you have some really good patents or print publications that would invalidate, that you think would invalidate the patent, then maybe it's better to have those in front of the PTAB, because they're very specialized. They see this stuff all the time. They have the technical background to be able to deal with it. So maybe you can get a really good answer on that from the PTAB. If you have other types of grounds, if you have product prior art or some other kind of prior art that the PTAB won't look at, then you're going to have to address that with the district court. So I think those are a couple of the key considerations. I think Andrew and Jeremy can, and you, David, can share some additional considerations that you have as well.
Yeah, so I guess, Andrew, why don't we turn to you? Can you comment on either success rates or on costs, for example?
Yeah, absolutely. And these are some of the strategic considerations, and I think what we would call advantages, and advantages to the petitioner, right? Not necessarily the patent owner. But so for success rate, I think we might talk about this a little bit. Things have changed a bit in terms of institution rates in the last few months, and we'll get into that a little bit. But if we were to look at, let's say, the fiscal year of 2024 and that data, the institution rates are fairly high. I think for 2024, it landed about around 68% for institution. Now, that doesn't mean that you win necessarily, but that means that the board thinks that there's enough of an issue to take up and to consider each side's positions and arguments and go through this whole trial process. And then for petitions that are instituted, it's usually about 30% of the challenge claims and about 50% of the instituted claims that are found unpatentable. So those are pretty high numbers and pretty high rates for unpatentability being found by the PTAB. If you really were to look at all of the claims being invalidated, right? So 100% killing the patent, it's dead. No claim survived. I think it's a much lower percentage, but that all comes into your strategic consideration too, right? As a petitioner, are we going to challenge all of the claims? Are we only going to challenge the claims that are being asserted against our client, the defendant, and the district court? That all comes into play, which is also connected to the fees, right? So there are a couple different fees that are associated with filing a petition. I will say pretty much unequivocally that they are much lower than proceeding through years of litigation and discovery and a trial. So not taking into account, though, of course, the attorney's fees in preparing and filing. The fees, I think, end up around like low 50,000 for filing a petition. And then about half of that is recoverable if the board decides not to institute. So,
And to be clear, that's fees that you pay the patent office, right?
correct. Those are fees that you pay the patent office, again, not considering attorney's fees or anything else that's going to go into the prep of the petition. But I think anyone out there that's either on the in-house side or the outside counsel side that has reviewed bills for intense patent litigations that are very busy and going through discovery periods, that's a lot less, right, than even just, and I don't know anyone's bills, but even just a month of bills when you're really heated up in the depths of litigation. So the cost is a huge consideration, right, for the defendant. And also, it ends up saving the patent owner a little bit of money too if they move forward with the IPR and potentially stay the litigation, which is another consideration and another advantage, again, more so for the defendant, but there is an opportunity or a possibility that the litigation in the district court would be stayed in light of the IPRs. Very court specific, right? Anyone that has any experience with IPRs and stays knows this. For example, in the Eastern District and Western District of Texas, they tend not to stay the litigation in light of IPRs unless they are very, very favorable, in fact, heavy in favor of the defendant. there are several factors that the courts will look at in that instance. Some courts won't even entertain a stay until the IPRs have been instituted. So there's a lot of things to consider. Of course, that's a 6-month waiting period from filing the IPR to actually knowing whether or not it'll be instituted. So a lot of considerations there, but it is generally an advantage for the most part in favor of the patent challenger.
So while we're on the, Andrew, you mentioned discovery. Jeremy, you want to comment on just the differences in what the kind of discovery is available at the PTAB versus the typical depositions, RFPs, interrogatories, RFAs that you would see in a district court litigation?
Sure. Yeah. So as been said, the IPR process is very fast and it's very streamlined. And part of that is discovery is very limited. The most common type you get is referred to as routine discovery. And what you get there is, of course, any evidence cited by the opposing party in a brief. So they have to serve on you the exhibits they rely on. That includes the patents, printed publications, other evidence they rely on, and any declarations from their declarants. And I guess it's worth noting that the testimony in an IPR is typically only through declarations, right? There's no live testimony absent very unique and very rare circumstances. Routine discovery also gives you the ability to cross-examine any declarants relied on by the other party. So if they put in a declaration in one of their briefs, you're going to get a chance to cross-examine that declarant. And then a final type of routine discovery is I think rare in my experience. You have to serve on the other party any information you have that's inconsistent with a position you're taking in a brief. I've never seen that happen. Beyond that, upon agreement, there can be initial disclosures that are submitted by the parties, and then during the trial, the parties can automatically take discovery of the information in the initial disclosures. That's also very rare. But as you can see, and that's basically it. That's what you get with routine discovery. So no interrogatories, depositions of folks who haven't put in a declaration. It is very limited when compared to the district court. You can get more than is provided by routine discovery through additional discovery, but I think that's fairly rare, and you have to ask for permission and to file a motion requesting it. And I think it can be difficult to get that additional discovery in large part because the PTAB is going to want you to already have some evidence in your possession that this additional discovery is going to turn up something useful. So again, in the post-grant review trials we're talking about, discovery is very limited, very much unlike in the district court.
Great, and thank you for that. So that's on slide 16 where we summarize some of the advantages. I'd like to comment on one of the disadvantages, or I guess a change that we've had recently, and we'll turn to slide 17. That towards the end of March of this year, the acting director of the USPTO implemented a new set of procedures where there's now two versions, or I guess two hurdles for a petitioner to overcome. The first is the director or her appointee will review for discretionary denial. And then after that, the petition goes to the board. So talking about that first hurdle, I've seen, and panel, I'm interested in your thoughts on this, but over the last 3 or 4 months since this procedure has been implemented, if you average across the number of patents or excuse me, number of petitions, I've seen about 60%, maybe a little higher, of the petitions get denied just on that first stage by the director alone. She's often commented on things like, well, the patent's been enforced for over 6 years, so there's a settled expectation of the patent owner, or about a district court trial will proceed so much earlier than the PTAB. So basically, why should the PTAB duplicate work? But I've seen since, again, over the last 3 or 4 months, just getting past that first hurdle, about 60% of petitions have been denied just for discretionary reasons like that. Has the panel seen similar statistics, or they've had similar experiences?
Yeah, Dave, I'll say I have seen similar statistics. I personally have not had any experience with the new the new standards and the new procedures for discretionary denial. But I think the one that you mentioned, and obviously, of course, want to hear my other panelists' thoughts as well. The settled expectations, I think, is kind of what's really been the hot topic and the hottest issue with this new procedure. So just to put it in context, I know one of the recent cases that came out this week, one of the recent decisions, the patents that were being challenged while they had been around for 10, 12, 15 years, they laid dormant, I think was the phrase that was used, for all of that time until 2024, until the patent owner started to assert them. And that they said that's enough. These patents have been around for a while. We shouldn't be focusing our resources and our energy on these old patents. We should be focusing on important cases and newer patents. It's just an interesting concept and an interesting argument. As we know, there are how many millions of patents out there, and just US patents, right? How many US patents? I don't even know what number we're on. I think we're close to 13 million, right? Or are we in the 13 millions already, right? And so for everyone to to have an understanding of all the patents that are out there, right, that could potentially be asserted against their client, or you being in-house, that could be asserted against your company, seems daunting to have that knowledge and to know whether or not you could potentially be accused of infringement on any of those patents that are out there. So just an interesting, I think, and very hot topic currently. And I'm curious what Jeremy and Brooke have to say about some of the other recent decisions.
Yeah, we actually went through a ton of the recent decisions trying to make heads or tails of it, because we had a case that went through that new procedure with the discretionary denial briefing. And our takeaway was there are two big risk factors for a petitioner. The first one is fintive, which means that if there's a parallel district court case and that trial date is going to come before a final written decision would issue, that's a strong indicator. I mean, there's a strong risk that the petition is going to get discretionarily denied. And the other one, of course, Andrea, as you mentioned, and David too, is this settled expectations idea, which, from what I can make of it, it's just if a patent has been in force for, and it's hard to say, I mean, 5 years, 6 years, or more, then I think there's a very strong risk of discretionary denial. And we went through the briefing. One of the arguments that had been made but wasn't successful was, what about the settled expectations of petitioner? You know, Andrea, you said there's these patents out there and they've been laying dormant for 10 years or whatever. And then a lot of times the defendant, the accused product, has been on the market. They've been making and selling it for a long period of time with no challenge by patent owner on these patents. And so you'd think there'd be sort of a counter argument to the settled expectations of patent owner because they haven't been asserting their rights while this accused product is on the market. But those arguments haven't had success. So again, I think if you have a fintive issue or you're going after a patent that's been in force for 5 or more years, you're at risk.
Yeah.
So, Jeremy, assuming the petition, and then this is all hurdle one. After that, and this is really discretion. After that, the merit, it's two separate adjudicatory panels. The first is from the director herself or her appointee, and the second one is from the merits panel, which will then look at, is the prior art any good? How strong are the arguments? So just so folks are clear on that. So let's, moving down the line a little bit, and big picture, what are some of the disadvantages from a petitioner's perspective, which I guess could be advantages from a patent owner's perspective to these PTAB proceedings? Jeremy, you want to cover that one?
Sure. And I think we've been talking about what I view as the number one potential disadvantage is that risk of discretionary denial, which has always been there. It's been there for a long time. But this new procedure and the director's recent guidance has really changed the landscape, as we discussed. But beyond that, I think the next biggest one would be estoppel. And basically, once an inter partes review reaches final written decision, the petitioner is stopped from re-challenging the validity of any of the claims that are addressed in the inter partes review on any ground that the petitioner reasonably could have raised in the inter partes review. So in essence, the petition needs to set forth the petitioner's best invalidity case, because once the inter partes review concludes, options for pursuing invalidity are really limited, right? I think you could probably continue in the district court. I think the Federal Circuit recently approved this on system art. So rather than patents in printed publications, if you have a prior art system, you might be able to pursue invalidity in your parallel district court case, but your invalidity on patents in printed publications is effectively dead. And I think this can be challenging for a petitioner, given the limitations that are also mentioned on that slide of inter partes review. You have, a limited opportunity to develop the record. Once you make your case in the petition, you can't really change it. You can't change your invalidity theory in the inter partes review in your reply or anything like that. And there are strict word limits. And I think another thing that makes it tough on petitioner, particularly in view of estoppel, is the petitioner needs to file quickly, right? Particularly in view of the new discretionary denial landscape. The earlier you can get it on file, the better. And so it's a lot to do in a short amount of time in a proceeding that's somewhat limited in your ability to address the other side's counter arguments and evidence.
And these are excellent points, Jeremy. I'd also add on, especially in view of your comment about the rush, not really the rush, but the importance of getting a petition on file early, is that from a petitioner's perspective, oftentimes they have to do that before having a patent owner's infringement contentions or before even knowing which claims they're accused of. But just all they have is the patent and maybe one representative claim, but it may not be clear to the petitioner how they infringe or what the basis is. So that could be an advantage to a patent owner if there's they'll have perhaps a preview of the invalidity. In district court, a patent owner has to put forth their infringement arguments before knowing what the other side will respond in validity. But one advantage for a patent owner is that oftentimes, in view of these discretionary denial procedures, they'll get the petitioner's best invalidity case before having to disclose even which claims they're accused of, or what the infringement theories are. All right, so let's talk about declaratory judgment, because that's another consideration in the interplay between district court and the patent office, the PTAB. So, Brooke, I'd like to ask you, how does filing a petition at the PTAB affect declaratory judgment actions, and vice versa? How do declaratory judgment actions affect the ability to file a petition at the PTAB?
Yeah, so by statute, if you file a declaratory judgment for invalidity, you cannot file an IPR. So there is a bit of a workaround to this, but essentially that means that if you're going to file a declaratory judgment, you should be very careful that you're only filing it based on non-infringement. Essentially how you would kind of bring up your invalidity arguments there is you'd file a declaratory judgment for non-infringement, and then when the opposing party would then argue that you actually are infringing, then you can bring up invalidity as a defense to that in the declaratory judgment proceedings. That would not limit your ability to file an IPR. But essentially, I mean, this is something to keep in mind is being careful about if you want to file a declaratory judgment to be able to preserve your right to file an IPR down the line. I think that that's something to consider. Is a declaratory judgment the right move at this time? Or is it better to just wait or file an IPR instead? So I think that that it's just an additional consideration looking at what the right venue is for challenging invalidity and at what point.
Great. Let's turn to slide 19. And Jeremy, I want to turn back to estoppel that you talked about. Can you give us a little more explanation? Basically, what is estoppel and when does it occur? And what's the practical effect of it?
Yeah, so touched on this earlier. Estoppel basically prevents a petitioner from re-challenging the validity of any claim that was addressed in an inter partes review that reaches final written decision. and that petitioner is prevented from invalidity challenges, future invalidity challenges on any ground that they reasonably could have raised in the inter partes review. So effectively, once the inter partes review reaches final written decision, petitioner has taken its shot at invalidity. And I think that is part of the purpose of the PTAB and these post-grant review trials is it's an alternative to addressing invalidity rather than as something that was designed to be cumulative with respect to invalidity, say in the district court. And it attaches or occurs once the final written decision comes. There's a little bit of a safety valve if the final written decision didn't go petitioner's way, in that inter partes reviews are limited to patents or printed publications. And so estoppel wouldn't prevent a petitioner from litigating the validity of those claims again based on system art, because the petitioner couldn't have used the system art in the inter partes review, and thus couldn't reasonably have challenged those claims based on that system art.
System art are products that were on sale or in public use, that kind of thing.
Right. Right. Actual products rather than, paper patents and printed publications.
Got it. And one thing we've been saying over the last few years, sometimes people would do it or not, but now it's almost routine, is petitioners will often file a stipulation at or around the time they file their petition, where they say, if, for example, district court goes to trial before the PTAB proceeding is finished, we will act as if the estoppel already applies, even though technically by statute it doesn't apply until final written decision. But we will agree that estoppel applies in district court as if there were a final written decision, just to help overcome some of these discretionary considerations. Have any of the panelists seen cases where these stipulations were not filed, or do you see that they're pretty much always filed nowadays? And since those new procedures took effect? Just the ones I've noticed, it seems like it's almost a matter of course now that people are filing these petitions, at least stipulations, at least since March and those new procedures, but in case the balance be different.
I agree with you, David, and especially in the current meta, I would be terrified of not filing that sort of stipulation with what the discretionary denial panel was going to do with it. And if I recall, back under Director Vidal, I think it was a Sotera stipulation, sort of like what you've been talking about, was basically an out from FinTIV issues. You weren't going to get discretionarily denied under FinTIV if you filed the right stipulation. And under Director Stewart, it's no longer sufficient, but I wouldn't imagine running the gauntlet of discretionary denial with a parallel district court case without putting in a stipulation. I feel like there'd be a big risk there.
Mm-hmm. Okay, so speaking of district court, let's move on to the next slide. And these are slides 20 and 21, 22. Andrew, can you, as you know, oftentimes there are parallel proceedings where you have one proceeding going on in district court, someone's sued for patent infringement, they turn around and file a petition for IPR or PGR at the PTAB, and the two are going along together. Can you describe some examples of the interplay between two of them? And I think we'll get into a lot more detail in a later webinar as part of these series. But can you give our audience an overview of just how these two proceedings impact one another?
Absolutely. So this type of scenario has become quite common, right? A lot of the strategy and the motivation behind filing an IPR in a lot of cases for the defendants is so that they can stay the district court litigation, kind of focus all of their resources on the IPR and save some of those resources that otherwise would have been used on the district court litigation. Most courts, and this is something that everyone should check if you're in this situation, whether you're the defendant and you're thinking maybe we might file an IPR, maybe a PGR, maybe even an ex parte re-exam, right? Is this something that we need to notify the court of early on? Is there something in the court's standing orders or in the local rules regarding parallel proceedings and notifying the court and all of the procedures you need to follow in order to do so and not get chastised by the court. I will say in my experience, it's usually been something that accompanies a judge's standing order for, you know, a Rule 26 report, and then something that would be discussed at the Rule 16 conference early on in the litigation. So I would make sure that you're aware of all of your court's rules and local rules, and make sure you understand how to handle the interplay between the two. This case that we have up here, Virginia Innovation Sciences versus Samsung. This is an instance in which the defendant, Samsung in this case, filed a number of IPRs. I think it was several IPRs against all of the patents asserted in the district court case, and did not inform the court until the IPRs had been instituted. Now, sometimes in certain courts, they don't even want to hear about a motion to stay until the IPRs have been instituted, right? And you have to assess that. And you have to look at your courts, the precedent, and what the court stance usually is on that. However, in this case, usually that happens a little earlier on, right? Because you have the 1-year time bar, and most petitioners try to get their IPRs on file sooner rather than later. But in this case, they were mere months away from trial. And then that's when Samsung decided to inform the court that they had a number of IPRs against the asserted patents. That judge was not happy. Obviously, if you look up this order, saying that there would be sharp consequences if parties continue to do that and not inform the court of parallel proceedings, that obviously could potentially really impact the case in the district court. All the patents and most of the claims, or all of the claims being asserted, could have been invalidated. So something to consider. Make sure, again, I think I've said this 3 times already, but make sure you know your judges' standing orders and the local rules to understand how they like to handle the interplay between the district court and and any other related post-grant proceedings.
What about motions in limine, Andrew? Have you seen judges' willingness to let discussion of IPR go to the jury, a jury be told about it, versus shutting it down in an MIL?
Yeah, so I think a lot of these cases here that we have up, it can be a mixed bag, and it depends on obviously the facts of the case, and what's going on in the particular case. Sometimes the courts agree that it's prejudicial, that there should be no mention of a failed IPR, for example, right before the jury. Sometimes they agree that evidence could come in. There's a lot of different factors that the court will take into account. One thing that I think it's been pretty consistent is if there are no issues of invalidity or validity being presented at trial, then really what happened at the PTAB is of no relevance to the case, and really just stands to prejudice the defendant or the petitioner in that case, and kind of potentially taint the jury's view of the patents. Maybe, oh, they're a lot stronger than they actually are. But in most cases, I think anything that's mentioning failed IPRs, or mentioning successful IPRs, it's really going to be up to the judge to make those decisions, and it's going to be really fact dependent. But I think one of the facts that I've seen that's been pretty consistent is if there's no validity case being presented, right? What does that matter to infringement or any of the other issues at hand?
Yeah, and I've also seen the other way around, the patent owner trying to, if let's say a petition is instituted, but there's not been a final written decision, I've seen patent owners successfully get mention of the IPRs excluded as not relevant because there's not a final written decision.
Right, absolutely.
Does anyone on our panel have anything to add on district court versus IPR and any of the interplay between them before we move on to the next topic? Okay. And let's talk briefly about claim construction. It is on slide 22. I have seen many courts, if it's within the claim construction process and it's all before the judge, so the judge is deciding it, so you don't have to worry about the unfairly prejudicial. I have seen judges use as evidence arguments made during PTAB proceedings as evidence to use for claim construction as intrinsic evidence. Have others seen that as well?
Yes, that's right. There's a Federal Circuit case, basically what patent is PTAB, their POR. the evidence as to the meaning of the terms in their patent.
Yeah. So let's from petitioner's perspective, and then I think we'll look at those considerations from the opposite, from the patent owner's perspective as well.
Sure. So I think one of the key considerations, especially after these new discretionary denial procedures that we've discussed earlier, is deciding on when is the right time to file. In many or most cases, because the director is looking very closely at when the scheduled trial date is, oftentimes petitioners are going to want to file as soon as possible, especially if you're in a court where that moves very fast and where they're not likely to delay trial. But there are also some other considerations because of the estoppel issues. You may want to wait and see, spend some more time looking at potential prior art, whether those are patents publications or things that could be presented in a district court. So I think that there are some arguments to waiting and seeing what actually is my strongest invalidity ground that I want to go after, instead of just filing, within 4 or 6 weeks after the complaint is filed. Maybe take some time to look and see, is this really going to be worth my time? Is this the best argument I want to present on invalidity? And of course, you have to file within a year, so you can't wait forever, but you can wait until you get a little bit more information. Some other considerations is this going to be a better argument for the more technical PTAB judges, or is it something that we could present better to the judge or jury? And that can deal with some additional issues, kind of like some external issues that may not be specifically like within the patent for print publication. And deciding, if this is going to be better for other kind of more lay people, like in the jury, who might go with more of a kind of gut level type decision on whether or not something is valid or invalid. And then you also want to consider what patents are being asserted in district court, and which ones do you actually want to pursue an IPR on, or if you want to pursue an IPR on any of them. So for example, if you have one patent that's been asserted against you that's you have a very strong invalidity position on, but the other ones you might not have as strong a position, maybe you just want to go after that one. If you want to maybe bring something into settlement negotiations, you could file IPRs on all of them, and maybe that'll encourage the other side to settle, because you have all of these other proceedings in another venue or another court. So I think that those are some main considerations. Andrea and Jeremy are welcome. You're welcome to add to those as well.
Yeah, I would just mention on coming back to the motion to stay issues that we discussed. And part of that consideration, the last bullet point, the multi-patent considerations, certainly part of the thought process and the strategy to go in there, I think would be, is your goal to get a stay, right? Because if you're challenging just one patent and a couple claims out of that patent when 5 patents are being asserted, I mean, maybe I'm speaking out of turn to say it's very unlikely, right? You're going to get that stay in the district court. One of the issues being like simplification of the issues. Well, you might end up validating a couple claims of this one patent we're asserting, but what about the other 4, right? So that's something to consider as well, I think, in part as part of the multi-patent consideration, also tying back to the motion to stay.
Yeah, and I'll follow up on what Brooke said about checking your art. You won't be able to, as a petitioner, you will not be able to get away with hand waving at the PTAB. The art has got to be spot on, whether anticipation or obviousness. It needs to be good, strong art. There needs to be good reasons to combine. And just within the last week, I think the USPTO issued a memo that said in the past, it was a little unclear, but some people would try to fill in missing limitations. Let's say that prior art didn't disclose a certain limitation. They'd say, oh, well, would have been obvious anyways. They'll just have an expert say, yeah, everyone knew about that. So they've tightened that within the last week, I think, and saying that you can use what was generally known or common sense or common knowledge to help provide the glue to stick multiple references together for a combination, but you cannot use it to substantively fill limitations. So they're taking a very close look at the prior art and they'll look at the claim charts, look at the obviousness, and so don't try to pull one over on the PTAB judges. They either the patent owner will call you out on it if they're good, and even if they don't, the judges read it and they'll see things sometimes that the patent owner doesn't even read. Speaking of patent owner, let's talk about considerations from a patent owner perspective. So turning to you, Jeremy, so recognizing that if a defendant gets sued for patent infringement, oftentimes they'll file an IPR. What are some considerations from a patent owner's perspective in terms of how they can respond or what they can do?
Sure, and I think one that's not on the slide that I think is particularly important in the current
And slide
landscape.
24 we're on for those watching or listening, but please, Jeremy, continue.
Yeah, right now, especially the time to trial in a parallel district court litigation is a key factor as to whether, you go after a defendant and they file an IPR. Is that IPR going to be successful? How quickly you're going to get to trial in district court is really one of two key factors for my understanding of the discretionary denial decisions that we're seeing recently. So if I was patent owner, I would of course prefer to sue in a district court where a trial is going to come quickly, because that's greatly going to increase my chances of having the IPR discretionarily denied. So that's one consideration. I think also, and this is sort of a complicated topic, the patent owner needs to be aware of who defendants' real party and interests or privies are, because that can have an impact. For instance, a defendant has to file, and this is a simple example, has to file for any inter partes review of a patent within 1 year of that defendant or any of its real parties and interests or privies being served with a complaint alleging infringement of that patent. So you could have a situation, this is similar to one I experienced, where let's say a manufacturer of a product is sued for patent infringement before its customer who is reselling that product is sued. If that relationship, which is something patent owners should look at, between the manufacturer and the reseller is such that they are real parties in interest or privies, the 1 year bar for the later sued reseller to file for the inter partes review would actually run from the date that the manufacturer, its real party in interest or privy, was served with the complaint, right? So that's an example of real parties in interest and privies changing sort of the timeline in this instance from when the 1 year bar runs. And the actions of real parties in interest or privies can bind petitioners in other ways. For example, the estoppel we've talked about today at the final written decision, it stops not just the petitioner, but also the petitioner's real parties in interest or privies. And, another example is multiple petitions from real parties in interest or privies, so not just from a single petitioner, can be viewed as improper serial challenges to a patent, leading to discretionary denial. So again, I think it's very important for a patent owner to consider who the defendant's real parties and interests or privies are, and that may help them get IPR petitions discretionarily denied or, have an argument about the time bar. I think also on this slide is how many patents to assert. In my experience, I typically represent petitioner, very rarely patent owner. It's harder for a defendant to request inter partes reviews, and this probably goes without saying, on multiple patents, particularly given the need for those petitions to be filed quickly to mitigate the risk of discretionary denial. So if I was patent owner, I would err on the side of asserting more rather than less patents. It's going to give you a better chance of defeating the IPRs that at least used to be likely forthcoming. Now it's probably going to be reexaminations, but.
Yep. Thank you for that. So with the time we have left, and we've been speaking generally about considerations, and we're on slide 25 here. Let's walk a little more into the timeline of just how an IPR progresses. Again, we kind of started a big picture about the considerations, the pros, the cons, how it relates to district court. But now let's use the time we have left to really get into the mechanics of how things progress. So let's start at the first step, the filing of the petition, like T equals 0. Andrea, at a high level, can you just walk us through what generally needs to go in that petition?
Sure. So all of the items are listed here on this slide. And what slide is this, David? 26.
26.
So you have to put forth your grounds for standing, right? It's not the same requirement as it would be in the district court, which is actual harm or injury, but the petitioner still has to show that they are not a stopped declaratory judgment of invalidity. There's no declaratory judgment of invalidity pending, and they have not exceeded the 1-year bar, right, which Jeremy just discussed. That is a statutory requirement that the petitioner has to make clear in their grounds for standing. Of course, an identification of all the challenge claims and the grounds being whether it's a 102 or 103 argument that you're making, whether you're combining multiple references, make sure that that is all clear and set forth early on in the petition before you get into the nitty gritty. Claim construction, right? So in my case, usually we'll say that we don't believe at this time any claims need to be construed. That's not always the case, of course. And also something that should be brought to the board's attention is whether or not the claim terms that are being challenged have been construed by a district court, whether it's in your parallel proceeding or in another proceeding. Maybe they're related patents that you're not actually challenging, but the same terms and they share the same specification. So just make sure that you're apprising the board of any of those relevant decisions. And then of course, explaining your grounds for unpatentability, walking through each of the limitations and why you believe they're unpatentable. All the relevant evidence, explaining all of the evidence, usually an overview of each of the prior art references or patents or written publications that you're relying on. And then an identification of real parties in interest, which Jeremy, of course, touched on. This could be a hot issue. It can be grounds for dismissal if the real parties in interest are not correctly identified by the petitioner. So make sure you are dotting all your I's and crossing all your T's when it comes to real parties in interest. Of course, copies of relevant evidence, you submit exhibits just like you would in any other motion or paper being filed with the district court. And then the fee, which we mentioned before. I think total right now it's around like 54,000 for the
Right.
two separate fees to file.
Great. And then Brooke, with the minute and a half or 2 minutes we have left, can you just walk us through this timeline? We're back on slide 25, and this ties into the back and forth nature we talked about earlier.
Sure. So 3 months after the petition is filed, the patent owner has to file a patent owner preliminary response, where they challenge the grounds of invalidity, essentially focusing on trying to make sure that it is not instituted, the IPR is not instituted. And then 3 months after that, the board is gonna issue a decision on whether or not to institute. This is the area where there have been a lot of changes over the last couple of months because the acting director has instituted a bifurcated process where she will review the issues of discretionary denial separately. So essentially what happens is that the patent owner is going to file a brief explaining the reasons why they think the IPR should be denied institution. And then the petitioner is going to respond to those. The acting director is going to look at that first. And if
Brooke, why don't we proceed to the trial phase, just because we're about to be in, but maybe do you want to
Oh,
wrap
yeah,
up
no
with
problem.
just the trial phase, what's to come in the next minute?
Yeah, so after it's been instituted, 3 months after, the patent owner is going to file their patent owner response. And if they want to, a motion to amend the claims. 3 months after that, the petitioner is going to file a reply responding to the patent owner's arguments. After that, the parties can request and often do request an oral hearing before the board. And then the board will issue a final written decision. And again, that comes 18 months after, or less after the petition is filed.
Well, thanks very much to our panelists. I think if our audience has any further questions, please contact Brooke Parker, Jeremy Albright, Andrea Schofstall, or me, David Tobin. We will plan to have some additional webinars where we get more into the details of various phases here. And if this is PTAB 101, then the next one will be 201 or 301, where we get into much more topics. But we thank you all for your attention and hope you enjoyed the webinar. And thank you again to our panelists.
Thank you.
Thanks, everyone.
Thank you.